Good evening. Welcome to Land Title Talk, where we encourage you to text in your questions at 904 501 4481, 904 501 4481. I am Steve Collins from Land Title of America. Grateful to have you with us. And as always, I have my guest with me here, Russ Stolium, also known as Rusty Collins, the Law Office of J. Russell Collins, and affectionately known as Rusty Law. Thank you for being with me, Rusty.
Hey, it's always fun. It gives us a reason to get together without the phone ringing.
That's right. Well, that's not true. We just don't. We actually ignore it when we're here when the phone rings. But we don't ignore your text. So, Rusty, what's going on in your world?
Nothing.
Good. All right. So,
but give me a week or two. We'll see.
Okay. Well, I'm sure there's plenty going on in your world. Just nothing you can talk about.
Nothing to talk about.
All right. So today I wanted to talk about an interesting situation, and the situation. And let me just make full disclosure. Everything I'm telling you is made up except for the, some of the facts. Does that make sense?
The concepts.
The concepts. So how would I say that in English?
Well, okay. So the concept you're talking about something that's real, but you've changed the facts.
All the facts.
To protect the innocent and guilty.
Right. I appreciate you putting it that way. Okay. So I want to make sure that as I say names and as I say amounts, all of those things have been changed. Even the dates, just so you know. What the weird thing is, it's all a public record, really, in Duval County. So it's not like it's really that private, but it's just one of those things where I don't want to talk about it here online. All right. So we have a situation where in 2017, an older man who we'll call Bob Jones, wanted to sell his property or actually didn't really want to sell his property, but an investor came along and offered him $100 grand for the property. The investor had the Bob Jones sign an option to purchase, an agreement for $100,000. Okay. The buyer on this deal would be Mr. Investor, as trustee of the Bob Jones Land Trust. Okay. Now, nothing ever materialized, except for there was a mortgage that showed up in the public records against the property, signed by Investor as trustee of the Bob Jones Land Trust to Investor's Company, LLC. Now, when the Bob Jones found that out, he freaking had a coronary, and
he freaking out.
He freaked him out. Yes, that's a real word, by the way. I coined it today. He freaked out and got an attorney, and basically sent a nasty gram, and Bob Jones released the mortgage. But what do you think Bob Jones did after that?
Whoa. Who released the mortgage? Bob Jones?
I stand corrected. Investor as trustee of the Bob Jones Land Trust. Okay. Released the mortgage. But then recorded a notice of contract. Okay. So this is going on for a long time, right? We're almost up to 10 years now, right?
Yeah, we're getting there.
We're getting there. Bob Jones dies. No one knows where this original option is. There's just a copy of it.
Okay. Is a contract, is an option? What is it?
It's a contract.
A contract for sale, not an option.
I would say that it's a contract for purchase and sell. But the terms are so vague as to when they could do it. It's like it's his option to buy it for $100,000 when he gets around to it. It may become someday. There's really no end date. Okay, it was just I have a right to buy it, and there was, according to Mr. Investor, there was consideration given for that potential option to buy in the future for whatever price for the $100,000. Okay, I think it was like $5 grand or something. Okay.
Okay.
So Bob Jones dies.
You don't care anymore then?
He may not. Actually, I think he does. He's up in heaven saying, dude, I got whacked here. And the original agreement is nowhere to be found because Mr. Family wants to buy the property. Okay, we're going to say Sally. Okay, Sally wants to buy the property from Grandpa's estate. Okay. But in the process of doing that, Mr. Investor shows up and says, no, I've got an option.
But he doesn't have a copy.
He doesn't have the original.
Does he have a good readable copy that looks like it wasn't photoshopped?
He has a good copy that Sally says does not look like Grandpa's signatures. Okay. Mr. Investor wants 70 grand to get out. Give me your opinion on this.
I'd want to see that contract.
I'm telling you what the contract says. You got to take it.
No.
Listen,
the words matter.
Okay.
In the contract.
Because of this show.
Is there a defect in the contract?
For this show, okay.
Do I have a good legal description? Is everything stated properly?
You do not have a good legal description, but you have a good address.
Okay.
Okay. You have a consideration of $5,000 for the contract for $100,000 with no closing date. Sally comes to you and says, Rusty, I want you to defend me. And I want you to make this option guy go away.
Give me $70,000 and I'll make him go away.
Okay, well, that's what she doesn't want to do.
Okay. I think there's a case to do that.
Okay.
But it's going to depend on these documents because.
Well, we got to make things up here. Okay. This is a real case. Okay. And let's take some things as if they're true.
So wasn't a FAR form, was it?
No.
It was just a handwritten or
typed up 3-page agreement.
And it doesn't have a date for closing.
Does not have a date for closing.
There you go. It's defective.
So without a date for closing.
There's no date for performance.
When he gets around to it. When he produces it, that's the den date. When I give you the $100,000, you'll sign a deed.
No, there has to be, okay. You got to have a performance date.
Do you have to? Are you 100% sure of that?
You have to have something. You have to have a way to calculate.
I know something you don't know. They settled, and the attorney representing Sally was settled because he's like, the main problem they had with this judge up in Jacksonville was Bob Jones wasn't around to talk to. They couldn't validate anything.
Or invalidate
anything. Sally swears that Bob Jones' signature is not on that contract. Sally also swears that if Grandpa did anything, Bob Jones did anything, it was under duress. Okay? You got to look this up now.
Well, I'm just wanting to make sure.
So the issue is that the attorney for Sally believed that, we're not going to win this case, or there's a fear that we may not win this case because we have no way of validating Bob Jones, what he did. We can't talk to him.
Oh, I can find Miss Cleo.
No, Miss Cleo wasn't available. She wanted too much money.
The if come maybe when I get around to buying it for $5,000 does not sound. There's no performance is part of the contract.
I get it.
Okay.
Performance is part of the contract. I get that.
And so all that Mr. Investor can do is seek specific performance. And I don't think you have what's necessary for specific performance, which is a date or a way to calculate the date. saying when I give you the $100,000 is not a good way to calculate a date.
Well, I agree with you.
That's not
I agree with you.
specific.
But Sally's attorney,
How much did they settle for?
$70,000.
I mean, the thing is there's probably no way to, unless you do an
Now remember,
end run
I'm
around.
still making up numbers.
I know,
okay?
but they paid what he was asking.
Yeah.
Okay, whatever that number is.
Yeah. Whatever they
So,
negotiate. Yeah.
The it may have been something that would cost her that much to have a fight.
That's what the attorney was worried about, was that by the time you fight this, we may have $70,000 wrapped up in it. You might as well just pay the $70,000, settle, and move on.
That is a viable answer in many cases.
Okay.
Okay.
But so Sally, so I guess, Rusty, what I want to turn this conversation to is, at what point do we have slander of title? And by the way, define what slander of title is, please.
Slander of title is when you record something that slander defames the title.
Okay.
Okay. A false claim of lien.
Okay.
I mean, if I go work on your house and you don't pay me and I file a claim of lien, well, I'm not a contractor. Therefore, that would be slander of title.
So if somebody owes me money, and I've had people call me and say,
I just want
this
to file
man,
a lien.
I want
Yeah.
to just file a lien.
Yeah.
We can't do that.
I want to file less pendants. Well, that's kind of dumb, because you have to have a case filed, because a less pendants doesn't put a lien on property. It just points to a case.
Right.
So it has to be a case to point to. So there's all kinds of things people do that can slander title. Purposely doing a wild deed to kind of mess things up. That's a slander of title.
Okay.
And you can be held liable for even.
What are the
fees.
consequences of a slander of title? If somebody
sues you and
sues you,
wins, you
mhm.
may have to pay damages, whatever the damages are. Because if it hurts something, if they could have sold the house for 100, and because of the delay, because they had to fix the title, it can only be sold for 80, and those proofs can be made, then you may have a $20,000 judgment plus attorney's fees.
It's not criminal, though.
Not that I know of.
Okay.
I mean, if you get to the point of fraud or something, and the
Well, let's
state attorney's office wants
let's
to do
go back to
something.
the situation where Bob Jones had signed the option with Investor Trustee of
You
Bob
keep
Jones
saying
Trust.
option. I get that's a problem.
I get it.
Okay.
To me, it's an option, because it's like he gave $5,000 and he has the option to purchase it for $100,000 at some point, and that's why I keep using that terminology. And I apologize for using the wrong term. It was a contract to buy.
Okay.
Okay, it was a contract to buy. Now, but Investor of the Bob Jones Land Trust recorded a mortgage, Rusty.
But
I know he released it.
he did, but here's
But
the thing.
could that not just show that, hey, we got a slimy guy here?
Slimy doesn't always make you win. I've seen lots of slimy guys win. Okay.
Okay.
I've seen lots of slimy guys make it to where we had to pay money.
That's true.
To,
Make the slimy guy go away.
right. And the slimy guy did what the slimy guy did, so that he would have to be paid to make it go away. Yeah. And not every one of those kinds of things is actionable, or it's not always a crime.
He recorded a freaking mortgage, dude.
But he didn't say but there was no deed to the trust.
There was not a deed to the trust.
So what good was it?
It wasn't any good, but it still clouded the title, did it not? Yes.
I don't know.
What do you mean
I
you
got a
don't know?
question. I got a question. Okay. So
Would somebody write title insurance on that property if there's a recorded wild mortgage like that? Come on.
I probably know one title company might, but
No.
no. Oh, where's your gut? No guts, no glory.
No.
Okay.
No. Nor any title company would with that wild mortgage out there, because
How
we
would
don't buy ourselves into lawsuits.
Right, but how would you even find it in the index?
Because Bob Jones Trust. Investor, trustee of Bob Jones Trust. It says Bob Jones in the trust name. They would index it that way.
It might come up on an index.
It would come up.
But again, how would they make the connection?
Well, it's the legal description. Bob Jones, even though the investor signed as trustee of the mortgage, I'd still have issues with that. It would be a cloud on title. It would slander the title. And so, I mean, this guy's obviously, I mean, how easy would that be, Rusty, to find dead people, come up with agreements, copy their signatures? No, I'm not trying to teach anybody anything here, you know, and then record, well, I have an option to purchase, or I have a memorandum of contract, right?
Right.
Okay. So how easy would that be? Now, person's dead. You backdate that sucker. How are you going to refute it? Family members come up and says, that's not a signature.
Somebody needs to use a better version of Photoshop then.
How many
Determine.
contracts have to be notarized?
None of them, as far as I know.
Okay. So a purchase and sell contract doesn't have to be notarized.
Of course not.
So
A deed doesn't have to be notarized.
they record
unless you
a
want to record it.
memorandum of a contract
Yeah.
with, and the memorandum is only signed by the investor.
And all it is notice that there might be a contract out there.
That's right.
All it is notice. So
I think a memorandum of contract without the seller's acknowledgement is a form of slander of title. Without,
if it's not true, it's slander.
oh, okay,
Okay.
okay, that's it. I like that.
Okay. A mortgage is slander of title too, unless it's true.
Oh, okay,
A deed's a slander of title unless it's true.
this is true.
So the truth of something beats slander or defamation. So, but here's the thing: in this situation,
Mm-hmm.
outside the cost of litigation, all that guy can do is say, "I want specific performance of this contract." Correct?
Right.
Okay.
He wants to buy it from the estate for $100,000. Properties, by the way, is worth $200,000.
Based upon a contract that was done in 2017. In this.
Right.
Okay. And whatever copy he has does not show a performance date.
No.
That is an essential term of a real estate contract. You cannot specifically perform, require specific
My specific
performance.
performance is when I bring you the money.
That is not definite.
I agree with you.
Okay, but it has to be definite.
You have proof
There's
of that?
case law about that.
Okay.
Okay. And
I think
again,
it's important to know.
Well, okay.
I think that's important to know. If you want to do a valid contract with somebody, you need to have a definite date.
Okay, well, you need to have a definite date. You need to have a definite piece of property
Right.
that can be described. I mean, I've litigated this issue
Definite terms.
with a contract or an agreement that said that the legal description is going to be determined in the future by something else that happens.
Yeah, I know about that suit.
Okay, and after 4 days of trial, we won,
Right.
and we still won after they appealed. Okay, because a real estate contract has to be definite.
Okay.
So if you just now, if you say I'm paying $5,000 for an option, well, the option is for a specific period of time. Remember, an option is its own contract. Okay, an option is, well, you just go back to the basics of a contract. I offer to sell you my pen for $1. You say I accept, we have a contract. Right?
That would be a verbal contract.
It's enforceable.
It is
okay?
enforceable.
If you prove the terms, it's enforceable.
Yeah. If we
Now,
both are totally
right.
100% honest and we go to the judge,
but here's
even
the
though I don't
thing.
want to perform, if we do that verbally and I agree to buy
Only
your pen for
certain
$1
contracts have to be in writing. Now,
under the statutes of fraud,
right,
real estate.
real estate contracts, or
And that's not based on because it's being sold for 100,000. It's any real estate.
right.
Whether you even if you sell the real estate for $1, you still have to have a written contract
That's right,
under the statutes of fraud.
right. But we're going back to the basics of a contract.
Right.
So when I say I offer to sell you my pen for $1, I've given you the ability to bind me to a contract by saying I accept. Okay? Because our consideration for the contract is the exchange of promises. I promise to sell, you promise to buy.
Right.
Okay? Basics of a contract. Now, at any time before you say I accept, I can withdraw the offer if I communicate that I'm terminating the offer. If I do that, then I terminate your ability to bind me to a contract by saying I accept. Make sense?
It does.
Okay. Now, if you say, I want to think about it for a few days, I want to think about whether or not I want to do this.
Okay.
Then if you want me to not withdraw my offer, we need a separate contract that says because you're not promising to do anything. Okay?
Right.
We're not exchanging promises here.
Right.
I'm going to promise to not withdraw my offer to sell you my pen for $1, and you're going to give me something
To hold that.
for my promise. You have
For
to
your
give me
promise.
something for my promise because you're not promising. You have to exchange something else, which would be money. Okay, now, if you have an option contract that says for $10, you can bind me to this contract for a piece of property. We don't really care about how much the consideration is, but the money better change hands, and that has to actually happen. If the money does not change hands,
But there still has to be an end date.
there's an
of
end date.
that
There has to be a
option.
date. But the point is, you have to give me money. And if you say you gave me money and money didn't change hands,
Void.
it's not enforceable because
Void.
I can withdraw.
Right.
We didn't enter into that contract because you didn't give me the money.
Right.
Okay. And that's a near and dear concept in my heart because that's the first client, the first case, the first trial that I ever had and that I won from that very simple concept.
And you went to the appeals
And it was appealed
and you won.
and I won. And I was up against somebody who was a wonderful man to watch. He's amazing. Okay. But I had better facts. Okay. That's bottom
No
line.
matter how articulate and beautiful his show was.
I wanted to be like him when I grow up, and he's 10. I'm 10 years older than him. Okay, but it was the facts. Okay, now what you have here is a contract that supposedly most people signed.
Supposedly.
If I give you $100,000, then okay, that's sort of like an option, maybe because there was consideration for
There was.
something. But
$5,000.
But an option would say you get to bind me to this contract that's attached to this option agreement. Okay, not that you get to bind me to a contract we haven't negotiated yet.
Right.
Because how can that be done? Okay, you have to have a
But in
contract.
this case, it was a contract.
If it's the contract form,
and it wasn't.
there must be a
I wanna-
definite date,
Okay. And there wasn't.
a performance date. Because how do you know if the seller, I'm going to give you the $100,000?
Then
Fine, I
why
don't
would
wanna
a
close.
judge? I don't know.
I would think if you had the actual document, okay, they were who sued who?
The Sally sued the
Sally
investor.
sued?
Yeah.
Okay, well, she didn't have a copy of the contract.
She had a copy of the contract and said it wasn't Grandpa's signature.
Okay, that's fine. So assuming it's Grandpa's signature, and there
But we're
is
not
no-
assuming it's Grandpa's
well,
signature.
but for purposes of why we should win without too much hassle here is assuming that's Grandpa's signature.
Okay.
There's no end date. That is an essential term. That's contract fails. And we want a
Should they have
declaratory
fought that then, Rusty? If Sally
depending-
would have hired you, could you have fought that and prevailed? Do you think under the fact that there was no? I think the more prevailing argument is that's not his signature. But how do you prove that?
Well, but if you can get it with, even if it was his signature, they
Right.
lose.
Okay.
Okay. So, but if there is no performance date, that's the issue. Okay. And it doesn't, make sense that you'd have a real estate contract that was binding for
I tell you what
That
this
means-
was, Rusty. This was a mortgage.
what's the mortgage.
This whole thing was a mortgage.
Well, you definitely changed some facts then.
No, because what happened is I think Bob Jones was desperate for money. I think Mr. Investor says, I'll give you $5,000 now. I have the option of $100,000 to take this property if you don't give me my $5,000 back. I think that's what happened. Okay. I don't think that he ever intentions of really buying this property. I really don't. I think and I think some of these investors will get a hold of people trying to buy property, and then people are like, well, I really don't want to sell. I just need $5,000. Well, I'll give you $5,000. I'll have an option we'll put a contract together for $100,000. And what will happen is
I'll
that
let you out for $5,000.
I'll let you out. No.
For $10,000.
Yeah. Whatever they agree to.
I think that'd be very, very, very.
I think if
scary
Bob
for
Jones,
the investor.
I get it. But I think if Bob Jones were alive, that's what would have happened. The fact that he recorded that mortgage is a
How much
telltale
was the
sign.
mortgage for?
The contract price.
For $100,000.
Yes. But it doesn't matter now. I'm intrigued as to how you would have attacked this for Sal.
Number one, the devil's in the details that we're not talking about.
And I get that, and we're not going to put the details on this show.
But at first blush, okay, you got to have a definite contract.
Right.
And
there's the out.
That's the out that I'd go after first. I don't know if you can do that successfully if you're on the offense. I think it's very successful if you're on the defense. This can't be enforced against us. And I can think you can say, I want a quiet title suit, or I want a declaratory action saying this judgment's no good.
That would have been interesting
this contract's no good.
To file a suit to quiet title on that memorandum of agreement.
Well, it'd be to get rid of that, or it's a declaratory action saying it's not valid.
Right.
That's what I would be going after that's my first thought. But again, devil's in the details.
Right.
There may be some innocuous piece of information that would change the whole analysis.
Right.
But
right, and I'm not asking you. I mean, you can only talk about what you know in this example. But it's not like somebody's going to look at the case and then say, "Well, Rusty, you were wrong." We're just basically just surmising on what I've shared with you. What would you do for Sally?
Yeah, but these are not high concepts either. These are simple. These are simple real estate contract law.
Well, tell that to the two attorneys fighting over this thing.
Well, they want to win, okay, and then but the real thing is you've got actual litigation costs. Yeah. And if you have an attorney that's hitting you at $350, $400 an hour, it can be a problem. There's all kinds of things that can happen.
Right.
And if you can control the crash and come out okay, we're not hurting Bob anymore because he's dead. We're hurting somebody's inheritance, which is less important sometimes.
And I love my investors.
Right.
And we need them.
Of course.
And I'm grateful for them. We had an investor on, 2 weeks ago.
Right.
Okay. So I like what our investors do. I think what an investor can do in this case, Mr. Investor, who went to Bob Jones, just do a legitimate deal.
But Bob Jones did not want to sell his house.
That's true.
Okay, so there is no deal to be made.
You're right. Probably stay away from it. But in the case of if Bob Jones is willing to sell his house for $100,000 and they're willing to record a memorandum of contract, I think that the Mr. Investor should have a memorandum of contract, which is fine, but have Bob Jones sign that and acknowledge that memorandum of contract. I think that's cleaner, Rusty, than having just a random, because we could do memorandum of contracts on any property you want to cause problems, especially on dead people.
Remember, but a memorandum of contract is not a lien.
It's a notice.
All it is notice. Well,
right.
It's notice of something else. If that something else does not exist,
I get it.
Then there's nothing there.
I get it, but
I mean, think about it. When a UCC1 financing statement is recorded, nobody signs it.
That's true. It's notice.
It's notice to go look somewhere else.
Right.
Okay. So
I like memorandum of agreements that are acknowledged by the owners.
Then why not just put the contract on record?
For some reason, people don't want to record the terms of a contract. And
that's because of if a deal falls apart or somebody exercises the right to cancel somewhere or terminate without breach, right. They don't want to have to put all this stuff on record.
And I respect that. That's why I just think a memorandum of agreement should be just, I've agreed to buy, he's agreed to sell. Here's his signature, here's my signature.
I think it's perfectly fine if they say,
I think it should be the right way to do it.
We have a contract that's pending and it will close by this date.
I think that would be the best way to do it. Makes it cleaner.
Well, but you can do it one-sided.
In the end, Mr. Investor has litigation costs too. And I'm making disparaging comments because I'm on Sally's side. I really don't know the truth. Bob Jones could have really signed an agreement.
But even
You
if
know,
you did,
and Bob Jones may have
but if you have a deal where it's open ended, okay, the investor should have done a better job.
fine, but and that's why I'm saying, okay, what could he have done? Had a better contract, okay,
And a time frame
with
to
it
perform.
in time, a memorandum of agreement with specifics of end date.
Why was he so worried about a memorandum? He only did the memorandum of agreement when he got beat up over the mortgage.
Exactly. He was afraid he was going to lose out on this transaction.
Oh, he should have lost out just because he filed that mortgage that was.
I
bogus.
get it, but he had some fear, I guess, and it may have been one of these situations where he talked to Bob Jones, got Bob Jones to agree, but then Bob Jones said, "No, I'm not doing this," and that might be what happened. I don't know.
In your timeline, how long from 2017 was this mortgage recorded? Right away.
Pretty much right away.
Okay.
Yeah, the memorandum agreement wasn't recorded till.
Till the mortgage was.
Yeah.
See, I think that right there.
There's a lot of.
If that kind of a fact right there would be an equitable reason for a judge to make him lose. Okay, there's some.
It'd be much more interesting if Bob Jones could tell us what really happened.
But without a performance date, we don't need Bob Jones to tell me anything.
Okay.
The contract fails for lack of specificity, and that's why do you think the real estate contracts that real estate agents use have a closing date on it?
Right.
It's
Makes
a
sense.
very important term.
That's good for the seller. They need to know.
Well, but we also have to have a performance date.
There's that company going around signing listing agreements, for lack of a better word.
Yeah, the 40-year listing agreement.
40-year listing agreement. Same
Yeah.
principle, really.
That is, but it's all, well, we're going to give you $500 or $1,000, and we have the right to list your property if you sell it for the next 40 years for 7%.
Basically, whatever you sell it for, they're getting 7%.
Right.
I mean, that's pretty good interest rate, isn't it? They deem that unlawful, right? That got.
I haven't
down.
seen that, or I don't know.
I think if you look it
there's
up,
if
that
there's a
was
thing
that
about
was
that.
challenged in court, and I think they're bye-bye. You don't see any more of those.
Hey, I'm in litigation now with a company that said, we'll give you like a bridge loan, and if it property, so you can buy a new house, and then if it doesn't sell, we'll buy your house.
For what price?
They had a
Okay.
a situation, yeah, but of course property values dropped, and so they charge a bunch of fees up front, and then they go. The time runs out. No, we don't buy houses. What are you talking about? Actually, I've checked them in Duval County. They did buy some houses in Duval County. They probably made some money because the values were fine. But on $114,000 loan, they had $11,000 in fees.
Ooh.
Oh, and the mortgage is due in 87 days.
Wow, man.
So
Is that an active case you have going on right now?
I do, yes.
That's
And
pretty gnarly.
That's
Why would that
usury.
be? Yeah.
That's
Explain.
almost loan sharking. Loan sharking is at 45%, and that's a felony. Over 25% is a misdemeanor, and you cannot, if it's a misdemeanor or a felony, you cannot enforce the loan in any court in the state of Florida.
So that mortgage gets thrown out. That
It should.
company or mortgage company, whoever they are, loses all the money they invest.
They should lose all the money they invest. Now, the proof is in the pudding, and there could be a
Wow.
settlement that might change it.
If you had to
But
boil that,
I want to win that one just so I can talk about it.
if you had to boil that down for our listeners, try to explain that to them what you mean and,
Okay.
and how that could affect.
When my son was selling his house in Valrico to move to Duval County, he needed a bridge loan.
Okay.
He got a bridge loan that had no payments, but it was fine. Okay. He was able to
The
sell his house.
equity on that bridge loan was on what property?
Was on the old property.
Okay, the property he was trying to sell,
That's right.
which had a first mortgage on
It
it.
was right.
Okay.
So, and then when the house sold, they paid off the loan. It was perfectly fine. Okay.
When he sells his house, he pays off the loan. He
That's
had
right.
the equity.
He had the equity to do that. That was a perfectly good transaction. There's value in that transaction.
Right. On the bridge
Okay.
loan, if it took them 5 years to sell his property, wouldn't
I think there was a
year.
way to encourage them to get closed. Okay.
Like a year.
I don't know the exact terms,
Okay.
but
Probably a reasonable interest rate.
reasonable interest rate, reasonable costs.
Okay.
On this one, it's advertised as if you can't sell it, we'll buy it.
Okay. Who advertised that?
The company.
A company, not a lender.
They are also a lender. I think they have a lender number.
Okay. So they're a lender.
I have to check to make sure of that. But
So they basically loan them the money. What I don't get it. So they're selling their house,
they want to sell their house,
and they're basically saying, listen,
and we're going to buy another house, and they use the money to buy the other house.
the money from this house.
Right.
So basically, there's a mortgage on this house.
Right.
We pay off the existing mortgage.
No. They don't pay off the existing mortgage. They get it's a second mortgage position,
Okay. They get a
Okay.
second mortgage. Okay.
and
So they're just getting down payment money. Is really
the
what
down
it is.
payment money. But the loan's due in 90 days, but this one's mathematically 87 days. Okay. But those fees that they charge,
to do this or
To do the
provide
loan.
this service.
right? Those loan fees were over $11,000.
$11,000
Loan
Cost.
fees. Now, think about this. Now the interest rate of the loan is 0%.
Okay. All right.
Okay, but if you take
They've got to
11,000,
be getting commissions on the sales. I mean, they must be also a real estate company
they expected they were going to make money on the house sale too. But the point
because
is,
they're basically
but
going on a contract.
there's an $8,000 fee in this thing, plus some other fees that are these are the fees to the company that bought.
11,000 total.
Yeah, 11,000
But what they're
out
doing.
of 100. So that's a 10% fee, really.
Okay.
Now you take a 10% fee.
Okay, because so basically it's like because of those fees, it's a 10% interest rate.
Well,
So if it was a
Right.
1-year loan,
it'd
it'd be 10%.
Right. So for usury, you don't do the high math we do to figure out APR. Okay. You take the loan rate, in this case it's 0. Okay. Then you take the fees
Which is $11,000.
and you divide it by the loan amount, which would be 10%.
Okay.
And then you divide it by the number of years.
Well, in this case, it's
You divide it by 25%, which means you multiply it by 4,
okay.
which means the interest rate's 40%.
Wow.
And then if it goes past that maturity date that's set, there's an automatic modification, but it costs you 2.5 points.
Wow.
Okay. So we're going to see
And
what
then-
happens.
And with all of this, if in how many months he doesn't sell his house, they'll
Well, now
buy
they're
it.
in foreclosing. No, they're not buying the house. They're foreclosing.
But my point is that the old agreement was that if you don't sell your house,
They advertise it as after 90 days, we'll buy it.
they'll buy it, and the amount that they would buy it would be at some
Some number
number that they agreed
that
to.
worked out. Yeah. But,
Okay.
but here's the problem. They didn't do that. They say they don't buy them anymore, and they're in foreclosure. We're in foreclosure. They're foreclosing.
They're foreclosing the second.
And I'm defending. And when I finally, when I sent in my answer, they asked for time to respond to my affirmative defenses.
I bet you they did.
And today I did a request for admissions, and
The
today
admissions are admit this.
admit that you meant to charge this amount of money. I want to see them say no.
Oh, you didn't? Well, then give it back.
Well, no, yeah, it's just admit that you tried to screw my client over. No, you can have people admit things that are, and those are the kind of things. Admit that you agreed that you were going to do this, or admit that you meant to charge this fee, which is kind of a wild thing to say, but it's what it puts them in a bad way because they really don't want to admit that they meant to charge more than they should have. Right?
But they're going to end up buying the house.
Not anymore. They're going to end up.
If they had bought the house, they would still be in violation, right?
No, because they bought the house. It's no longer a loan.
Yeah, but when they originate the loan,
Well,
it's
that's
still
just it. There was a
bad
closing.
loan.
There was a closing package that was prepared by a law firm in another state. The doc prep type.
Yes.
Thing. I mean, it's all there. Okay.
But whether or not, Rusty, they buy the house, okay, let's say they buy the house, you still have the violation.
It's funny. It says
Yes.
I think so. If it's
Okay.
a loan, I say admit that the closing statement is an accurate representation of the disbursement or withholding of funds from the $113,000 loan amount, such that defendants were charged $11,225 as new loan charges. And they said deny.
Oh, yeah?
It's on the closing statement.
Who got that?
That's interesting to me. Admit that the defendants did not execute a loan modification agreement on lender's form as provided in Section 1 of the addendum. Well, they never did do that. They said deny. Okay, interesting. Admit that the reference in the closing statement to something home buyer means the plaintiff or an affiliate owned by the plaintiff. Deny. Really?
They just denied everything. They didn't even look at the whole thing.
Admit that the plaintiff intended to charge a equity advance fee of $22.75. They admit the plaintiff intended to charge a doc prep fee of $225. Admit the plaintiff intended to charge a modification agreement fee of $175. Admit the plaintiff intended to charge a convenience fee in the amount of $8,550 in consideration for extending the loan represented by the note and mortgage. Deny. I needed to pose somebody. So it's just interesting, but and this is one of those things where I'm pretty sure if my client could get them to walk away zero from whatever it takes when they sell their house to come out to zero.
Right.
Okay,
They would agree to that.
then they would agree to that. What they want them to do is that we'll do a short sale, but you got to sign a note for the amount that.
Heck no.
Oh yeah, I'd go to the mat.
Heck no.
That's a great way to try to undo something, but they'd still be actually liable for it because you can't cure it the way they're trying to cure it.
I get it. Wow. That's a crazy story. All right. I have one other thing for you here. So a situation we have is we have a guy who bought a property that was on tax deed, and the owner that lost it to the tax sale was a bank, National Bank.
Cool.
What happened is there were two parcels. You had parcel A and you had parcel B. They're right next to each other. Parcel B is a small 30-foot wide piece. Parcel A is like 100 feet wide.
Okay.
Well, they mortgaged both parcels, but they're in two separate tax bills.
So,
Well, the bank paid the taxes on parcel A, not parcel B.
so they got the
So they did
bill on A.
foreclosure. They did foreclosure.
Okay.
And the interesting thing too is the house is on the line. Okay. They did a foreclosure, and the bank was awarded the property.
Right, they're the high bidder.
Except for simultaneously the tax sale was taking place.
Okay.
Okay. So
On which day?
right in the same time period. Didn't matter. I mean, the taxes are going to wipe that out,
Right.
period. Doesn't matter.
Okay.
You could be the highest bidder and you think you're getting parcel A and B. You're not. You're getting parcel A.
The highest bidder, the tax deed sale, or the
Mortgage foreclosure.
okay.
Because the final judgment of the mortgage foreclosure and the certificate of title is for parcel A and B.
Okay. So why didn't they pay the taxes on both?
They just didn't.
Did they get notice of the tax deed sale?
I'm pretty sure they did.
Sounds like somebody made a mistake. Is going to have to do some work and have to write a check.
Well, what
to
happened
somebody
is
else.
that the bank sold the property, parcel A, to another investor, and they have a mobile home in there. They're collecting rent. This 30 piece has been sitting there. That this 30 foot by probably about 150 feet. Okay, has been sitting there.
Is that the part that's against the road?
Well, they're both against the road.
Okay.
I mean, they're so he's got 130 feet of road. Back behind this property is a nice lake. So the investor that bought the tax deed realized he has a parcel he can't do anything with.
Sure, he can. He can tell the people who own parcel A to get off his property.
He could, but didn't want to. So guess what he did?
I have no idea.
Signed a quitclaim deed to the bank and recorded it. Now the taxes are assessed to the bank's name again.
Okay.
Who really owns the property?
Oh, okay.
And then there was silence.
I think I don't think the title doesn't pass through to the buyer. Does
To the bank, you mean?
Does the buyer
Hold
does
on. The
does
investor and bank.
okay, investor, did they get a certificate of title for A and B?
Okay. Bank got a certificate of title for A and B.
Okay. Did investor buy A and B?
The tax deed investor bought only B.
Right. So, but when
The other investor only bought A. The bank figured out they lost the property taxes eventually
hmm
because there's a deed only for partial A.
Okay, so and then
Who owns parcel B?
I would think the people who got the quitclaim deed, the bank.
Rusty, they have no notice. They didn't accept that deed.
Okay, you're right. There is no delivery.
There's no delivery.
Although actually recording is considered delivery, but it's rebuttable. If they say that we don't want it, they can do that.
So now I have somebody who does lots of real estate. I didn't even say she's a friend of yours. Wants to buy parcel B. Who does she go to get a deed from? I mean, I guess she could go to the bank and say, hey, I need a deed from you. As long as the bank's willing to do it, that's fine. Now, the interesting thing is parcel B is going back up for tax sale.
That'll clear it up.
That'll clear it up.
That'd be the easiest way to clear it up.
Mhm.
But if the bank doesn't care, they could either do a quitclaim
The
deed.
bank's not going to
They're not gonna do a
accept
thing.
anything because of why? Liability.
Yeah, they want the liability.
They don't want especially on a lake.
So basically, the bank does nothing. They're going to be. It's going to.
They don't care.
It's going to erase it.
But this investor wants to try to buy the property for the tax deed sale because when property goes up for tax deed sale, and insane people bid up things they don't even know what they're bidding on. And this property really is not valuable except for the neighbors that surround that property. Truly. Maybe the bass in the lake,
But I don't understand.
I think the answer to the question is, Rusty, is that in all reality, the person we know,
Mhm.
this woman who wants to buy that property, that 30-foot
Mhm.
wide property that's 100 feet deep, I think we would have to get a deed from both the bank and the investor that brought it the tax deed because we do have a cloud on title.
Well,
If
you
the
have a
bank's
deed.
refusing to sign a deed.
Okay, but are they refusing to say that we got title? Are they refusing to say we accepted delivery?
Even if they say that, you've got to do that by quitclaim deed. Title company's not going to accept that. Oh, we tried to get a deed from them and they refused.
Well,
That's not going to be good enough for us. Oh, I'm going to record it.
It'd be interesting to sue a bank and say we're asserting that you did not accept delivery.
Yeah, see, that's a good point. I didn't think of
Okay.
that. I did not think of that.
Because if they
To
say,
maybe go to the previous owner and say, hey, give us a quitclaim deed, and then we're going to sue the bank and say they didn't accept delivery. And maybe get an affidavit from the seller saying he just arbitrarily signed this quitclaim deed and recorded it.
I recorded it thinking
Right.
that'd be done, but they've never accepted.
Because the bank's not going to respond to your lawsuit. Actually, that's a great idea. I will talk to my.
Well, that'd be the easy way out for the bank.
I didn't think about that, Rusty.
Okay, the bank doesn't want to they don't want to do something that's going to
They're
bring
not.
liability.
This is a big national bank, and they're not going to do jack diddly. Okay.
Well, they do stuff when they get sued.
Hey, I'm spilling water on your table in here. That's okay. Yeah, we got napkins. But
But I mean,
this is what happens when you're animated.
Yeah, well, I mean, I needed to clear up title where a bank took a mobile home because of confusion, and they ended up with a mobile home title for a mobile home that was the wrong number. Okay.
Okay.
And
Accident.
It was accident.
Right.
And it's a big bank. There's nobody to call.
Nah, they don't.
But when you sue them, they will respond. And what can
Or
we do to make this
not.
go away? No, they go like, what can we do to make this go away? Because they want to be on lawsuit because it shows up on your annual reports. Okay. And I said, simple. Give me a mobile home power of attorney so I can fix this. Okay. And they did it. I'm going to dismiss the case. But sometimes that's the only way to get their attention because if you try to call a bank number, you're talking to somebody in New Delhi who can't do anything but say, I'm sorry, I can't help you. Okay.
Exactly that way.
Yeah. And you know, and you just can't get to the right person.
Right.
But it changes when their law firm calls you and says, "What I got to do to make
Well,
this go
Rusty,
away?"
that is a genius idea to have this woman that we know
Can you
go to the person who did the investor that bought the tax deed, who signed the deed over to the bank, to get that investor to give her a quitclaim deed.
right?
And then she can then file a suit to quiet title, as long as he asserts that, yes, I did not communicate with the bank. I just recorded this quitclaim deed just to get out of it.
And then we want that
And do a
deed to
quiet title.
be considered not delivered and therefore not valid, and have the bank, and we say we can assert that the bank never accepted delivery,
Genius idea, by the
so
way.
that will rebut the delivery.
I should have talked to you before the show. This
Oh, wow.
happened 2 days ago.
Well, what are you gonna do?
So that's very interesting. But let's talk about acceptance of deed. So if somebody signs a deed to a family member, there has to be this delivery, right? You have to have delivery.
Okay, in
So
order for
explain what
property
delivery is.
transfer, okay,
Well, what are the elements of a conveyance?
okay, so back before we had recording laws and stuff like that, in old England, because that's where most of our laws come from. If I wanted to sell you a piece of property, I'd go out there with the property with you, out to the property with you, pick up a clod of dirt and say, "I sell you this 40 acres from this tree to that tree to whatever," and hand you the clod of dirt, and that's it.
That's interesting.
Okay,
You know,
that would be the
you've told me
transfer.
that before, and I'd forgotten about that. That's
So-
very interesting.
What a deed is the written version of that act.
Wow.
Okay, so, but in order for a deed to be valid
In the state of Florida,
in the state of Florida, you have to have words of conveyance. Okay. You must have who's selling and who's buying.
there must be consideration,
There must recite consideration.
recite consideration. Okay.
We don't care if you paid or not, but we recite consideration.
Okay.
And typically we say $10 another good and valuable consideration, but it can,
Right.
you can say for $1. You can say for love and affection too, if that's what you want.
You say for the household cat?
I don't know why not.
Okay.
That's consideration.
Yeah.
I don't want any cats, but anyway, you must describe the property with specificity on a warranty deed.
Okay.
On a quitclaim deed, hey, I lost a case once where the Exhibit A was not attached.
I don't know if I agree with that.
Well, I didn't either until I
But
realized.
let's not get off on that
No.
because that's a whole nother topic.
Okay, well, there was a parcel number though. But anyway, but for a warranty deed, it must describe the property with specificity, basically that nothing else can be described that way.
That's why we don't use addresses.
Because addresses change.
Yes.
I had an address change.
But legal descriptions don't.
They don't change much.
Yeah.
Okay. Anyway,
Or shouldn't.
right. And every piece of property in the state of Florida started off as a coordinate from a specific spot in Tallahassee.
Right.
So it's either north,
Section,
south,
well,
east.
it's
yeah,
townships and ranges and
Right.
sections within that.
Right.
And then we have the fun Spanish grants that screw everything up.
right. So we can, so you
And
go to
government
that.
lots.
Right. Well, government lots are inside the sections.
Correct. Correct.
But so you can have that, and then we have people that make subdivisions that take a bigger piece of property and make it into. We change the legal description to lots and blocks, which makes it much.
But it's a very specific description.
And there's a map. The old maps are kind of hard to deal with, but still, we got a map that shows where that is.
Okay.
Now you have to have that. It must be signed by the person who's conveying,
Right.
and it must be witnessed.
That's it.
And
No.
the deed must be delivered.
But okay. Delivered.
Which means I'm handing it to you and you're accepting it. I'm handing you the clod of dirt. It doesn't work if I just throw it at your feet.
But what's interesting is you don't have to have a notary to make that conveyance legal.
It's legal. It's just maybe not everybody knows about it.
You can't record it without
can't
the
record
notary. And that's such an interesting piece of that. The conveyance takes place when it's signed, witnessed,
And delivered.
and delivered with the things you listed, with a specific property, who
Right.
and what.
So
And then that's the conveyance.
that's the conveyance. We record to put everybody else on notice.
In order to record it in the public records, that's why we have the notary.
Right.
The notary does not validate the conveyance.
No, they just make it recordable.
Yes. Interesting
Now-
facts.
So what happens though, if Grandpa is a mail away seller,
Mm-hmm.
he signs the deed, sends it to the title company. The title company has it. Closing's at 3:00 today. Grandpa dies at 9:00 this morning. Guess what?
Deed passes.
No.
Whoa.
We did not have the closing. There's no delivery.
Oh, I'm sorry. I thought you said the day of closing was the day before.
No, he
You're
died.
saying that if we get a deed from Grandpa, he's already signed, it's been witnessed and notarized. Closing hasn't happened yet, and Grandpa dies.
The deed's no good.
Deed no good.
It's not
But if we
delivered.
have a delivery of the deed, meaning we got the deed from Grandpa, buyers came in,
And they've closed.
gave us the money,
that we're ready to disperse.
we're ready to disperse. Grandpa dies a
That's
minute
fine.
after, property already conveyed.
Right, because again,
Even
that
though
del-
it's not recorded.
right, but the delivery is kind of a concept. Okay, it could be a physical act. You can make them. You can hand them the deed if they really wanted to do that. But it's when everything is done. Okay, because obviously, if you've signed the mortgage and given your money, you've accepted something. Either that or you're nuts. Okay, but so that has to happen. When that happens, delivery's done, transfer's complete. So that's a very important concept.
Yes.
So,
What we insure.
right, and that's when the title company's liability goes up, because if Grandpa didn't die and he sells to another group of people that don't know about this conveyance, and your conveyance isn't recorded yet, they will become the owners of the property at the end of the day.
Yeah, that's a whole nother show,
Oh yeah.
which is fun actually to talk about. Well, this has been Land Title Talk. I'm Steve Collins from Land Title. I'm the sponsor of the show. You know, we call it Land Title Talk, but I don't know if we really talk too much title insurance on this show.
Is Land Title Pays, Rusty Collins Talks.
Yes, it's Land Title sponsored show, Rusty Talks. Well, we appreciate you listening. You can always text me at 904-501-4481, 904-501-4481. You can reach also our processors in our office at 904-797-9600, 904-797-9600. We don't like to make this an infomercial, but Land Title's been around since 1997. And we've been a part of the Collins Title family since 1970.
1979, we was originally our family opened the title business with my parents doing that.
We have
And
uncles and aunts.
we're the North Florida Title Mafia.
There you go. So we'd love to help you with all your real estate transaction needs. If you are buying or if you're selling, if you're mortgaging, you need a title company. We always encourage you to use a local title company and also a company that is writing title insurance, not represent you. We don't do both. If you have an attorney that's going to write your title insurance, that's great, but don't let them represent you. Have separation of church and state. It's the wiser thing to do. So again, we appreciate you listening. Rusty, how do they find you if they need you?
Call my legal assistant, Ben, at 904-829-6600.
That's it, 904-829-6600.
Because I sure as heck ain't answering the phone if I can help
Yes,
it.
so, but then that's how you call Rusty Law, and appreciate you listening. We're going to be back next week. Thank you very much.